Better life.
Sasa ukafanya hivi. Okay.
Tiake. Dili tadi bebika. Bunion.
Oh, sorry.
Takes great exception to the petitioner applicant's conduct that when favorable to them, issues of orders, or rather orders issued outside of what one would refer to as the normal or working hours of the court raise no concern. However, when the court acts in an instance where it has been moved by any other party and likewise proceeds to deal with an application at hand, the applicants show their indignation. Moving to petition E015, the CTS again would show that the same was filed on the 18th of October 2024, and once again following the directions issued by the court, this bench was empaneled on the 18th of October 2024 to hear all the three petitions, that is E565 of 2024, E013, E014, and E015, all of 2024. From this sequence of events, it is notable that the interaction between counsel and the courts on an almost real-time basis is not novel.
For those information, people have sent it to my phones because they have seen me on television. Where we have such a scenario that repeatedly they keep saying we are going to have what is it called? We are going to have a swearing in as soon as these three judges lift those particular orders. My Lord, that cannot create confidence, because assuming it is not this case, every party, and we have very many cases here, if somebody, you are drinking him in a bar, says, no, you are going to lose that case before the persons we are appearing before. That, my Lord, is a party. Parties are not lawyers. are not supposed to be sophisticated. That party will be left certainly with a huge, huge problem as to whether actual justice is possible. And it might actually be, my lord, that whenever else is dealt, the petitioners will win this case. As we expect, we shall win if the petition is heard. My lord, if that is the case, and that may actually be the case before you, but my lord, the scenario that is bad and that is prevented by the law is a scenario where the parties lose. Because they will say, well, you are Ahmed Nasir told us, Oscar Sudi told us, Kamket told us, and all these individuals who are saying it was called drama. We are here for entertainment. My lord, if judges are supposed to be treated to entertainment, and those judges are supposed to stop that entertainment, my lord, there is a problem on the face of it. There is a notice of appeal that we have filed, and it is part of the supplementary affidavit. In this notice of appeal, your lordships, we have pointed the issue, and we have said one of the other issues of concern is that the judgment of this court that dealt with these other issues, that judgment, the contents of that, amounted to preempting and answering the application that I'm arguing before the court. Because those issues we are submitting did not come from the respondents, but these applications having been filed, we are arguing these applications. After, in a previous ruling of yesterday, we have effectively been responded by the court itself. The petitioner says that they are absolutely uncomfortable with that, and they cannot be able to say that if we have reached a situation whereby judges are answering our case in advance, it is absolutely bad and beyond repair. My lord, the second last issue that I want to say is this. The issues, my lord, is, and we expressed that concern yesterday, we were not sure whether we would even file a notice of appeal as counsel. But you are told you cannot file this one because it is the issue, as far as we are concerned, we were not treated fairly. We were accused, we are playing to the gallery. As a result of the accusations and indictment that we are playing to the gallery, what effectively ended up being glossed over is the question of our own submissions. And my lord, the basis, and therefore the accusation, and we are saying we were not treated in a temperate and judicious manner, the petitioners and their advocates. Then, my lord, we go to the deciding for purposes of yesterday, the core issue. My lord, the core issue in our petitions, a number of them when it comes, would be the question, does the IEBC have the power to have authorized the president to say that Kindiki? I'm saying it is in our petition. I'm saying one of the issues that will be coming in for determination would...
My lord, I think it's important to just help my learned friend. We are not arguing the substantive application. It's a recusal. Let him stick to the issues.
Let him hear the issue and the answers. My lord,
but just do the right thing.
My lord, the point I was making is this. One of the questions, I want to tie it with the 165. And the question is this. The question that would be arising is whether the IEBC without commissioners could have declared Honorable Kindiki to be suitable for this nomination in the letter they did to the president. My lord, that particular issue is significant because the petitioners are saying that this court, having effectively read Article 165(4) in a manner that amounts to amendment of Article 165(4), they perceive the real danger that when a more important question arises, the same logic would be applied against them. And they are saying, this being a very serious legal issues, the bench cannot be said that for purposes of the issues actually in contention, that people can be oblivious of such an issue. I need like 2 or 3 minutes. My lord, having said that, therefore, it is our submissions. And as our Honorable Mwita has said, nobody extracts any joy to raise this kind of an applications because judges are legal colleagues. But my lord, the point that we also want to add for purposes of this application, this is contained, I believe, in the affidavit of my clients, is of course to point out to the issue. But the Honorable, the Deputy President, Rigathi Gachagua, by a letter dated 23rd of October 2024, did file a complaint against all your lordships. And this complaint was acknowledged by the Judicial Service Commission that it has been received. Then there is an issue that required disclosure. According to the petitioners, I wasn't even aware of this, I saw it today. According to the petitioners, is that there is a very close relationship between one of your lordships, the Honorable Judge Mrima, and the Speaker of the National Assembly, who is the Speaker of the Senate, who is a member of here. That close relationship, according to the petitioners, is one that ought to have been disclosed so that parties could be able to make up their mind that are you comfortable? And we do that every day. I've actually not proceeded in a number of matters for some of the judges who are my classmates, saying, Kibe was this, we were close, we were friends, are you comfortable? That question ought to have been raised. That issue was not raised, and as a result of that issues not having been raised, and now having come to public notice, the petitioners are of the view that it would not be proper to be able to proceed in this matter. My Lord, in conclusion, what I would like to add...
Before my learned friend concludes, I want you to be added another minute. Could he please, to assist us to respond, set out the nature of that relationship and where it is expounded in the affidavit?
Well, my Lord, I thought that can actually come during the response, as I said.
The duty, the burden of establishing facts is on the person pleading the facts. So we want to know that relationship so that we can respond to it.
Yes, my Lord, I have no problem whatsoever. There is a written affidavit. My Lord, in paragraph 6 of the supplementary affidavit, it reads as follows: whereas I was not aware about the relationship between the Honorable Justice Mrima, who is among the three judges handling this matter, and the fourth respondent, that is Kingi, it has been brought to my attention that the Honorable Judge and the fourth respondent, Speaker of the Senate, are very close friends, as demonstrated as here under. 1, the respondent attended the wedding ceremony of the judge and they took a photograph with him. Number 2, in a post on social media, he indicated...
May I please your lordship? I
thought I should finish.
May I say something? May I say something?
Yes.
The position that my learned friend Mr. Kipe had taken, in my humble submission, was most appropriate. We are not here to destroy professions. Disclosing some of the details may not be the right thing at all. I think one should make a reference in a tactical manner, which your lordships will be able to appreciate of what is going on. I would respectfully say to you that this is an area where we have also to protect the judiciary, the judges and the magistrates, the judicial officers. I'm not very sure that we should have an in-depth account of what really one is complaining of.
Let me explain that, my Lord. There is a new affidavit that has just come online that contains some of these allegations. It wasn't there before, and that's why we sought. Now, you may proceed.
My Lord, I think I agree with Dr. Kaminwa that unless, because as I said, I am not the source of any of this information, or something that came to my knowledge, that I was sticking to what my learned colleague is talking about, unless there is insistence by my learned colleagues. My Lord, I do not see the value of that insistence. I'll follow Dr. Kaminua's position. It is stated in the affidavit. I will not say anything more on that. The respondents can say we can have a rejoinder when the issue arises. My Lord, and the problem with these issues of somebody not continuing what they are saying is that he's making is this, that at the heart of an application for recusal, the authority speaks themselves, the one we have cited, I may not have time to go through them, is these issues that are considered very important. Number one would be whether, on the basis of the accusation and apprehensions set out, would one party feel that their right to fair trial before an independent, impartial, and fair tribunal be upheld? The petitioners on that score are saying their right under Article 50 to fair hearing, which is absolute, would not be possible in the circumstances of this case. Number two, there is a question of the right to protection of law under our Constitution. That right to protection of law requires that for it to be protected, there must not be any doubt that that protections would be availed if it is deserved in accordance with the law. The petitioners again say they have reasons to believe, as a result of all matters taken into account, that their rights under Article 27 would stand violated. And my Lord, the final issue, which is most important, my Lord, the final issue, it could not really have been final, but I have to finish. My Lord, the final issue that is critically important for this issue is the old notion, the old principle, that justice must not only be done, but must actually be seen to be done. In the circumstances of this case, it is our submission that apart from the real issues that the petitioners have, whether perceptions, whether substantial issues, the petitioners are saying that, Your Lordships, they are unable to say that at the start of these proceedings, we were confident that these judges are capable of upholding our constitutional rights and to uphold justice equally between us. My Lord, we are most observed. Thank you for letting me conclude substantially on what we set out to do. We are most obliged.
Thank you, my Lord. Before the next speaker goes on, I think there is something we are doing and it is not fair to the court, because my learned friend was challenged by Professor Mugay to tell you what is the specific thing. Then they take the posture, assisted by the senior, that we don't want to go there. You cannot eat your cake. The reason they don't want to go there, my Lord, is because it is frivolous. Now, the misfortune we have is this. The world is watching these proceedings. They said we don't want to go there. And the typical person watching things, there is something very serious about the integrity of the court that they have raised. When, as a matter of fact, going by the list he had begun, is that the judge attended their wedding. The judge went to a restaurant. In one of the applications, they said the judge went to some law school. Clearly, we are being unfair to the court. We want to paint a picture, hiding that we don't want to go there, so that the world will be left with the impression that there is something terrible about it. Cromwell, who said, if you want to paint a picture of me, don't embellish it. Say it what and all. If they have any allegations now that we are broadcasting these proceedings to the world, if they have an allegation of any impropriety against any judge, they can't make the claim for the gallery, then say, we don't want to go there. We submit
There's something wrong somewhere. My lord, I'm elderly. I've got weak ears. Is there something going on that's wrong?
That is the gallery. The gallery you're looking at. There must be something wrong with the gallery.
Yeah. My lord, may I address my learned friend? May I make a comment on what the learned friend has just said?
If you are using a gadget and your gadget
could be causing this noise, please just set it properly.
May I make a comment, my lord? May I remind my learned friend very, very respectfully. It is our duty to protect judicial officers also. And
they are not protecting the court, they are telling the whole world that this court is improper.
May I say what I want to say?
They can't have it both ways.
May I say what I want to say?
About when they apply for recusal,
May I say
you don't apply for recusal of judges.
I think the proper way, Dr. Kaminwa, let parties submit according to the directions which we gave. And according, again, there is an application supported by affidavit. There are averments in those affidavits, and because some of those averments actually touch on us, but we cannot defend ourselves, we would be satisfied if you read them even verbatim, so that the world knows that these are your complaints against the bench.
Please, may I say something? My lord, may I say something?
No.
May I say something? My lord, as your lordship is aware, at times when you are in a court, in open court, you will say to a judge or judges that I have information that I would like to, that shows clearly that you should not hear this matter at all. Can we go to the chambers so that I can disclose that? I'm not asking that we go to the chambers. All that I'm saying, as lawyers or as advocates, we are also under duty to protect the judicial officers and to protect the institution of the judicial system.
I think
that's all that I've said
okay.
Much more.
That is okay. I think one way of protecting judicial officers is by disclosing in open court like this what is there.
By being blunt.
Exactly.
I see. I am not with you with respect.
My lord, next time, I hope also don't have to say you must do it within 15 minutes, which is what they were trying, then accuse you for not reading everything. Because I have not actually read everything, there are other issues I could also have read. But my lord, let me read this. My lord, hearty congratulations to my long-time friend. That was underlined by and the source is Right Honorable Amason Jeffa Kingi, EGH. The petitioners said the issue, and that is the issue that I picked during my submissions, that there is a long-term friendship between the judge and a party. That long-term friendship ought to have been disclosed. I said that. Then it goes on to say, on the occasion of the renewal of your marriage vows with your beloved wife, this is now the evidence that they are giving. You are a true testimony to the belief that spouses resolve to stick with each other through thick and thin, great things can happen. I wish the two of you the very best in this long journey and pray that God continues to bless this union and imbue with wisdom and the patience that comes with marriage and family life. Hongera kakangu. And below there is a photograph where a gift is being given by the Honorable Mr. Kingi, Senator, to the couple of Judge Mrima and I believe his spouse. That is the annexure that was put by the petitioners in proof of the fact that there is a close relationship, a close friendship that under the law ought to have been disclosed, given that Kingi is a very important party for purposes of the case against the Senate, that he botched everything and has come here to defend those impeachment proceedings. I believe my job is done, and because that is all that it says, and that is the affidavit of the petitioners. Unless they need me to read something else, I can sit down.
The second applicant.
May it please you, my lords, my lady.
You are in another file, eh? Or we take it in another file or the same file?
Yes, my lady.
So it's not in the same file? Yes.
I am in 509, where we have the application.
509 is in cohort 1, eh?
Yes, cohort 1.
Give us 5.
Your Lordship, with profound respect, permit me, Your Lordships, to indicate that we are arguing the application dated the 22nd of October, with a further affidavit, Your Lordship, having been filed this afternoon through the court's email. Your Lordship, from the onset, it's with heavy heart, Your Lordship, that we have to move you through these mechanisms. And that, Your Lordship, my submissions are the submissions of my client, and that I am just a vessel for putting across my client's case. Your Lordship, there is a notice of motion that seeks the recusal of this bench. The same, Your Lordship, is supported with an affidavit and an annexure. Equally, the further affidavit is supported by 2 annexures. In my submissions, Your Lordship, I will heavily rely on the facts contained therein. The 22nd of October, Your Lordships, my lady. I'll begin by indicating and relying on the Judicial Service Code of Conduct and Ethics Regulation 2020, and I draw the attention of the court to Regulation 47. Regulation 47, Your Lordship, states that a judicial officer may recuse himself or herself in any proceedings in which his or her impartiality might reasonably be questioned, where the judicial officer, 1, is a part of the proceedings, B, was or is a material witness in the matter in controversy, C, has personal knowledge of disputed evidentiary facts concerning the proceedings, D, has actual bias or prejudice concerning a party, E, has personal interest or is in relationship with a person who has a personal interest in the outcome of the matter, F, has previously acted as counsel for a party in the same proceedings, G, is precluded from hearing the matter, H, a member of the judicial officer family, has economic or other interest in the outcome of the matter in question. A recusal by a judicial officer shall be based on specific grounds to be recorded in writing as part of the proceedings. Your Lordship, it is my client's, the petitioner's case, that this bench should recuse itself on the ground contained therein. Permit me to begin by indicating that yesterday, when the court was delivering its ruling, it indicated actual bias on the part of the parties before you, Your Lordship. The petitioners were condemned in a wholesale, in disparaging language coming from the bench, a language that indicated prejudice or bias on the part of the petitioners. It was indicated by the bench, Your Lordship, that despite the heavy submissions, the authorities that we quoted, we were not addressing the bench, but addressing the gallery. It is so prejudiced, Your Lordship, that such perception on the part of the petitioners culminated into the court not even taking note of most crucial issues that we had submitted on. For example, despite the appeal that is now being launched, the court failed to take into notice of the question of delegated authority. It is a considered submission, Your Lordship, that had it not been for the bias and the prejudice that the court has on the part of the petitioners, such would not have escaped the mind of the court. Your Lordship, further, the court made further remarks that they take great exceptions with the remarks of the petitioners. When the court indicates that they take great exceptions with the remarks of the petitioners, it's a prima facie indication that the court has descended into the arena of dispute, and that the court therefore becomes or takes a defensive approach in the manner in which the prosecution of the case is being conducted. Your Lordship, a judge must at all particular time be a solemn person, slow to anger, and of good temperaments. Your Lordship, the statement indicates that the court has taken a position as against the respondents, the petitioners. And the position is prejudicial to the petitioners and erodes their confidence to continue appearing and making submissions before this court. It was the observation of this honorable court, Your Lordships, that my client indicates that the court made further findings that the petitioners were not pursuing the urgency of the applications. What a reasonable man, a bystander, a fair-minded person, listening to these statements, internalizing them, will come to a conclusion that the court has taken a hard position on or against the petitioners. The test of a fair-minded person, Your Lordship.
My Lord, we really hate to intervene, but my colleague, if he is added time for it, it's okay. But let him tell you how, yes, the ruling you issued will be a basis for an application that was filed long before that ruling.
Your Lordship, if he may be patient, he'll have his chance to bite the cherry and respond in that manner he so thinks that he should. Your Lordship, the application has also indicated that Justice E. Ogola is closely associated with his spouse, who serves in the Water Kenya Towers agency. The averments of our clients, Your Lordship, is that this is a matter that ought to have been disclosed at the inception of the proceedings.
You mean the judge is closely associated with the wife?
No, I didn't say that. No, I didn't say that. That is not my statement.
Yes, what is it that you said? Repeat for the record.
May I repeat for the record, so that the court may not again misquote me?
Proceed.
Your Lordship, the spouse of His Lordship, one Florence Oluoch Auma. Yes?
There's a disposition of that.
Yeah, there is a disposition of that issue, Your Lordship.
That Florence is the wife.
Yes, there is.
Paragraph?
Yes, paragraph. Paragraph 13 of the supporting affidavit, as read with paragraph 11 of the further affidavit. She holds a position in the Kenya Water Towers Agency, an appointment that was done pursuant to the Gazette notice number 7515 of 2013, for and on behalf of the presidency by Siopan Tuya. Your Lordship, it may go on record that the sixth respondent who initiated or made this appointment is a party in these proceedings, and that the parties.
No, my Lord, that's not factually correct.
I'm not getting you right, and I'm sorry for intervention.
Where are you lost, my Lord?
Here. If I'm looking at the same document as you.
Yes.
The Gazette Notice 7515 was issued on the 7th day of June 2023 by Soipan Tunya.
That's correct.
Cabinet Secretary for Environment, Climate Change and Forestry.
That's correct.
The sixth respondent in this proceedings is who?
Is the president.
Then, where is the next one?
I'll get there. I'll get there. Your Lordship, the cabinet under the Constitution is constituted of the president, and the cabinet secretaries appointed thereafter, and the deputy president of the Republic of Kenya. That Siopan Tuya is an agent of the presidency. Your Lordship, one of the issues that was before the impeachment was that the deputy president, the petitioner herein, indicated that Kenya is a shareholding country. There are shareholding agreements before you, and that positions either in parastatals or corporations were to be shared in accordance to that share agreement.
That is the reason why his client got impeached. That is not anything that is before you for determination. That is the reason he got impeached.
He will be given an opportunity to respond. Even if you are itching, Mr. Nyamondi, take your cool. Your Lordship, it is my client's submissions that Florence Auma Oluoch may have been a beneficiary of that shareholding. Your Lordship, finally, Your Lordship,
Kindly,
we have...
just a minute.
It is extremely unfair and unjust, especially for an advocate to mislead or what you have said to play to the gallery. Can you read paragraph 12 of the affidavit? So that he does. No. Yes. Let's hear it from him, where he says that the said board is chaired by the president, who has. So can you kindly do it properly so that you don't?
I'm sorry, I'm not. Excuse me. No, excuse me. No.
Hold on.
Your honors, your ladyship, and my lords, they will have time, as you said, to respond and say all these things. If he's saying nonsense, they'll stand up and say so. But this constant interruption is intended to derail this hearing. Let them respond when their time comes. Yes.
And
stop bullying people.
And we abhor the condescending nature of the respondents. Everybody here has been instructed by a client either to speak sense or nonsense. So, that being the case, the condescending attitude is completely objectionable, and everybody should take their seat and use their time with sense. If sense can only come from them, they do it during their time.
Thank you very much. Sir, can I finish?
My Lord, may I be protected to urge my application and the respondents be granted opportunity to respond?
Finish what I was saying.
You will have your time.
I know I will have
to
my
respond.
Time, but please, this is the application being presented. Let's not have a thing.
It has been served upon you.
My lady and my lord, just permit me to say one thing. Just one thing.
Your Honor, if I'm allowed to just say something.
Just a minute, Council. Just a minute, Council.
Let applicants finish their case and then people will respond. Because this interjections is just going to affect the conduct of the proceedings. It's very unfair. Let everybody have a chance. Each person has 10 minutes, others have 5 minutes. Let them utilize their time. But these objections in between is unfair and it's affecting the flow.
Come to court and say that.
My lady and my lords, this is what I want to say. Just a minute.
Order. Can we have some order? Can we please have some order? Harvey, you may proceed.
My lord, a judge is first an advocate and second an advocate. We are all here advocates. My plea is we conduct these proceedings in an orderly manner. As Professor Githu Muigai used to remind us when we were in school, to be an advocate, you are a superior mortal. Can we just be slightly superior and deal with this thing in an intelligent way?
You are remaining time to conclude.
I am most obliged, Lordship. It may be noted that, Your Lordship, that the chair of this board is directly appointed by the President, the six respondents in this case. Your Lordship, may I submit again that the perception out there is that this bench has been constituted for a particular purpose, and that the bench is just a mere conveyor belt, and that the parties herein will not have the chances to have justice of their case being dispensed. Your Lordship, I have annexed a tweet by Senior Counsel Ahmed Nasir, annexed in our affidavit at paragraph 12, and I would wish to read that tweet, Your Lordship. Ahmed Nasir, Your Lordship, is a senior member of this bar, a senior counsel, and Your Lordship, here it goes. The conservatory orders will be discharged by the 3-judge bench, latest by next week, if not by Friday. Even as we approach you, Your Lordship, the perception out there is that this bench is part of the conspiracy.
Ahmed Nasir is not the law.
Your Lordship.
He speaks not to the law. Ahmed Nasir has also an affidavit. He is not a witness, my lord. How does Ahmed Nasir, and we have 64 senior counsel, how does Ahmed Nasir, how can his tweet inform submission before this court?
Well, may I answer that, Your Lordship, to the good professor, that we are speaking about perception. The standard of a bystander, the reasonable man, a fair-minded man in the status and the character of a senior counsel, Ahmed Nasir says, and the President's lawyer says, we cannot receive justice. That is the standard.
Ahmed Nasir says that this court will quash.
Mr. Ojienda, you will have your time to respond.
No, but the point is, he then speaks in your favor.
Yes.
Pick that line.
Let him respond. You will not teach me how to submit. You will pick the line that you so wish. For me, I am saying, Your Lordship, that the perception out there is that this bench has been constituted as a conveyor belt. Finally, Your Lordship, this court will remember that on the 16th of October, we moved the court for a mention on the 18th. The court declined to grant that mention and slated our filed to be mentioned on the 29th of October. But when they were moved by parties in these proceedings, the court was generous and gracious enough even to sit on a weekend, to sit on a Saturday. Noting that we were before you, you slated our matter for the 29th and never saw the urgency. Your Lordship, how can a fair bystander be convinced that this court will dispense with substantive justice? How can it be said that this court is impartial? Your Lordship, the question of a spouse being linked to a judge, as indicated by Rules 47, is of paramount importance, and it's something that cannot be ignored. Why didn't the court disclose to us? Why did the court conceal? If the court can conceal such kind of apparent evidence, what else is it capable of concealing? Your Lordship, permit me to indicate that in our affidavit that would wish to expunge paragraph 16 of our affidavit, supporting affidavit, will not rely on it, and paragraph 10 of the same affidavit will not rely on the same. But the standard, Your Lordship, is that of a bystander. Ahmed Nasir spoke, and he has a following of over 1 million on his Twitter handle. That is, the perception has been created to the Kenyans that this bench, 1, is a conveyor belt, 2, it is constituted for a particular mission, 3, it's part of the conspiracy. Your Lordship, we urge you to uphold our application and grant the prayers sought. Your Lordship, my learned friend Mr. Macharia will highlight on the authority with the authority in support of my submissions and those of Kibe.
A slight clarification on expansion. Paragraphs 10 and 16, if I had properly.
Yes, that's correct.
Of the supporting affidavit.
That's correct.
I don't know whether we can do that through oral submissions. You cannot expunge a paragraph from an affidavit as it is evidence before the court, and it has to be considered, it has to be challenged in all ways. Number 2, if you expunge paragraph 16...
Can you cover it in your response, please?
I may, but if you expunge 16, I have a problem with that. There is no application before you. If you expunge paragraph 16 from the affidavit, there is no application as being urged before you. So we need all this clarification. Let's not take things lightly.
Yes, Your Lordship, yes, it is true that the paragraph that I seek to expunge is paragraph 16.
I would like to address the question. I would like to address the question.
Paragraph 16 of which affidavit? By who?
Who's affidavit?
And 16 is
the applicant's affidavit. That is Obuli Namenya.
This is 10, 16
My Lord, permit me with
Perhaps, my Lord, again, because we have to be fair to the court, my colleague has to be candid and confirm to the court. The reason is withdrawing that paragraph 16 is because the claim there is factually false. Because you can't just withdraw and leave the world thinking...
We are not even seeing that paragraph 16. Can you read it, the paragraphs we want to withdraw?
And 10 and 16.
Your Lordship, are you having the same application?
Read as paragraph 10, which we want to withdraw, and paragraph 16, so that we can consider if it can be withdrawn.
Yes. Paragraph 16.
Confess it's a lie.
We give Mr. Dave or my lords, your leadership, the opportunity to finish his speech.
Yes. Let him read those paragraphs,
yes,
so that we can sit down.
No, I agree. I'm just saying, protect him from these tutorials that he's getting from this side.
Order. Please read as paragraph 10.
Your Lordship, I wish to say that most respectively, I wish to say no more in respect to the paragraph.
These are directions from court. Read paragraph 10 and paragraph 16.
Paragraph 16 reads...
Paragraph 10 first.
May I have some peace, Your Lordship?
No, listen.
How
please,
many people are in
please,
conduct
please,
of
please,
these trials, Your Lordship?
Listen.
Who is in conduct?
Listen. Bana Njiru.
Yes, Your Lordship, I'll read.
You have applied to expunge paragraphs 10 and paragraph 16.
Yes, Your Lordship.
Can you read those paragraphs which you intend to expunge?
Your Lordship, paragraph 16 says that...
Paragraph 10.
That do I have to read it out format? 10. And Your Lordship, may I take note that these paragraphs have been expunged? One,
we have not expunged those paragraphs.
That I have made an application to expunge them.
Can I read them for you?
The petitioners have credible information that Honorable Mrima is a close associate to the proposed Deputy President, one Mr. Kindiki, and that the said judge failed, refused, or neglected to disclose those facts to the parties at the inception. The basis of the application to expunge that particular paragraph is on the basis that the same has been linked to the affidavit sworn in petition 015. Paragraph 16, that Lady Justice Mugambi is convicted as she should recuse herself, as she was Mr. Kindiki's LLM student at Moi University.
We have no LLM program at Moi University.
You will have your time to submit, sir. Stop eating. And that's why I'm expunging it. That's why I'm expunging this paragraph. That is what my client said. A crucial issue that she failed and or refused to disclose to the parties. My client has learned that she was not an LLM there and that she only took her degree in that university.
We have no objection to anything being expunged, subject to the court observing that if this witness has lied about these two issues, what else has he lied about?
In a ruling, because application has been made and the response is there, but we decline the invitation to expunge those paragraphs. They will remain as part of the record.
My Lord, will you permit me to address you?
Dr. Kamona, we would appreciate if you want to address us in the course of the, as in you are submitting. Is that the position?
Yes, that's about it.
Okay, proceed.
Yeah.
What is the position?
My Lord, my position is this. Is that if there is a party...
Are you supporting the motion?
I'm supporting my land friends for complaint to Lebu and Chiru and my land friend Mr. Kip.
You need to go first.
Hmm?
Yes, then go first.
Oh, you want to go first? Yes.
Yes.
Do you have a prejudice if I talk?
Yes.
Thank you very much to my senior. My Lord, I'll take about 15 minutes. Mercifully, my issues are issues of law. They will not incite any shooting up from my respondents, or should not. My Lords, my Lords and your Ladyship, I have submitted some two cases. The first case is the case of Standard Chartered Financial Services and another versus Manchester Outfitters. I don't know that you have that with you. And the second is a case called Naveen Premjikerai versus Virunga Limited and others. In the case of Standard Chartered Financial Services Limited versus Manchester Outfitters, and this remains, as far as I'm aware, the first case where the Court of Appeal reviewed a judgment, a concluded judgment, set it aside and varied it. And the only question before that court that led it to this decision was the question of bias. I invite my Lords and your Ladyship to paragraph 1 of the decision, where the court says as follows in trying to frame the seriousness of the issue. And I'm reading from the second line. It is a rare application in which the applicants seek to have the judgment of this court reopened, re-examined, declared a nullity, set aside, and the appeal had afresh. I invite you now to go to paragraph 9. We've done back-to-back photocopying, but if you look at paragraph 9, in the middle is in bold the words Jasbir Singh Rai and two others versus Talukan Singh Rai. And the court is saying what it held. And it says this. During the pendency, my Lords and your Ladyship, are you there? In the middle of paragraph 9, during the pendency of the applicant's motion and the respondent's preliminary objection, this court in a 5-judge bench decision in Jasbir, and they give the whole case there, held inter alia, that it was only mandated to hear and determine appeals from the High Court and could not revisit its own previously concluded decision, nor did it have powers to reopen and rehear a finally concluded matter. In light of the decision in the Rai case, it was deemed appropriate that since this matter raises similar issues, it be similarly heard by a 5-judge bench, hence the unusual composition of this bench. They are merely underlining the importance of the matter the court was dealing with. Permit me now, your Ladyship and my Lords, to invite you to paragraph 63, where the question that vexes you this afternoon is dealt with. At paragraph 63, they deal with a case which we've also supplied the court and my friends with. This is a well-known case of Senator Agostino Pinochet. But at paragraph 63, this is what they say. Bias, whether it is perceived or actual, undermines the public confidence in a judicial officer's ability to dispense justice. They then cite a caption by Lord Joff in R versus Gao. Justice must be rooted in confidence, and confidence is destroyed when right-minded people, the right-minded people that Mr. Ndegwa was talking about, go away thinking the judge was biased. at paragraph 65, the case of Webb versus Queen, in considering the merits of the test to be applied in a case where a juror is alleged to be biased, it is important to keep in mind that the appearance as well as the fact of impartiality has been done. And this is what they say at paragraph 66. And this, my lords and your ladyship, is what I would be beseeching this court to find favor with when you retire to do your ruling. The rule against bias is as important an element of the right to a fair trial. This rule, and now this is our own 5 judgment saying this in the Court of Appeal, this rule is to be very strictly applied so that even the appearance of bias is done away with, the appearance alone. This is because it aids in public confidence in the fairness and impartiality of the judicial system. In view of the jurisprudential importance and uniqueness of this application, they then cite a case called R versus Sussex. Justice should not only be done, but should manifestly and undoubtedly be seen to be done. I will leave for you to read paragraph 67, which I also recommend to you. And then paragraph 71, another English case cited. First, actual bias will of course always disqualify a person from sitting in judgment. Even in the absence of actual bias, however, the importance of public confidence in the administration of justice is such that even the appearance of bias will disqualify. And they say emphasis added. And I would also invite you to look in the fullness of time to paragraph 73 and 74. Paragraph 81, they cite the case cited earlier, I think I mentioned it. This is the case of Agostino Pinochet. It actually begins at paragraph 80. There's a long passage, I'll not read it on account of time. But at paragraph 81, they cite the basis for the reason the 2 applicants before you have moved you. It's the Latin phrase, nemo debet esse judex in propria causa. No man is to be a judge in his own cause. Then at paragraph 82, Lord Hope, in the same decision, indeed, it may be said of all the various tests which I have mentioned, including the maxim that no one may be a judge in his own cause, that they are all founded upon the same broad principle. Where a judge is performing a judicial duty, he must not only bring to the discharge of that duty an unbiased and impartial mind, he must also be seen to be impartial. Having considered all those, the court, and in that case what the issue was that the late Justice Laka had represented one of the parties previously, not in this matter, but previously. But at paragraph 86, they give a summary of what I've told you, and then go to paragraph 88, and then this is how the court finally resolves the matter. And I will also recommend to you paragraph 90. Let me read paragraph 90 before going to the conclusion. The mere probability or appearance of bias was enough to breach the cardinal rule of fair trial in the administration of justice. Having raised the issue of bias arising from the same circumstances in the hearing of an interlocutory application by the same judge in a matter involving the same parties, we do not understand why the applicant's counsel failed to raise the issue during the civil appeal. That omission notwithstanding, the seriousness of the bias, of the issue of bias, cannot be underrated. As observed in the Benjo case, bias is one of the grounds that would justify review of a previous decision of the Court of Appeal. As I said, this was the first time it's ever happened in the history of the Court of Appeal, and as far as I'm aware, the only time it has happened. So at paragraph 95, this is what the court says. Accordingly, we allow this application, declare that there was a failure of justice in the judgment dated 4th October 2002, and we accordingly invoke the court's residual jurisdiction to correct that injustice by reviewing the judgment and setting it aside with all the consequential orders. Now, my learned friend, Mr. Kibe, has referred you to a passage that my good and learned friends for the respondents insisted must be read. And this is the question of the attendance of a wedding where gifts are shared by a judge who, the gifts are received by a judge by a party who is before this court. We are before this court because the first petitioner was impeached in the Senate. The Speaker of that Senate is a party in this case. In the document presented by Mr. Kibe, the speaker describes the judge, and there's nothing wrong with having friends, as I should say. I need to say this. He says, my long-time friend. This is what he says. Now, we found a decision, and I've shared it with you. This is the case of Naveen, where on all fours, a similar situation occurred. And I invite the court now to look at paragraph 70. And allow me to read this, because I won't be reading anything else after I read this. This is what the court, this, as I said, is Naveen Kerai versus Virunga Limited and others. I begin to read. I say paragraph 70, please forgive the coloration of the authority. And this is a 2022 decision. So both the Standard Chartered case and the case before you were determined under the current constitution. And as I'll be demonstrating here, they also took into account the Judicial Code of Conduct. I'm reading from paragraph 70. In this matter, the third respondent declined to recuse himself. This was a matter of an arbitrator appointed under Article 159, declined to recuse himself on the basis that the relationship between him and the counsel for the first and second respondents was a professional one. This court, however, takes judicial notice of the fact that in the Kenyan context, invitations of colleagues to weddings is extended to those that one considers close, and such invites are not extended to all and sundry. Had that been the case, then the third respondent could have as well extended the invite to the counsel for the applicant, who is an advocate just like him. Given the circumstances, this court arrives at the inevitable conclusion that apart from being a professional colleague, the third respondent and counsel for the first and second respondents are friends. And that is the perception that any reasonable, objective, informed member of society would reach based on the circumstances of this case. I continue, paragraph 71. As counsel for the applicant stated, it is common knowledge that there is the custom for invited guests to give gifts at a wedding, exactly as happened in the case Mr. Kibe showed you. In this case, apart from the third respondent and the counsel for the first and second respondents, the applicants and their counsel will never know if the counsel for the first and second respondents was a gift-bearing guest at the traditional wedding or not. In this case, we know, because the photograph depicts a gift. It, however, boils down to the failure by the third respondent to disclose to the applicants and their counsel that he intended to invite the counsel for the first and second respondents to his traditional wedding and seek their views on the same. I need to emphasize that the real issue here is not that a wedding was attended. It is that that issue was not disclosed prior to the hearing and dismissal of an application in this matter and the continued conduct of these proceedings. I continue. Bearing in mind the final nature of arbitral awards, which can only be set aside upon a litigant satisfying the conditions stipulated under Section 35 of the Arbitration Act, the need for disclosure becomes even more critical. Paragraph 72. In S versus Roberts, the court stated that the apprehension be that of the reasonable person in the position of the litigant, and that is based on reasonable grounds. I continue at paragraph 73. The counsel for the first and second respondents has stated that since he and the third respondent are arbitrators who have served at the Chartered Institute of Arbitrators, Kenya branch, as chairman and vice chairman of the institute respectively, during the same tenure, they were bound to interact or have interacted in the Chartered Institute of Arbitrators events, trainings, board meetings, and members' welfare gatherings while discharging their professional mandate. I do agree that the above events are professional in nature. However, weddings are personal events where families, friends, and close colleagues are invited. The lack of disclosure by the third respondent that he had invited the counsel for the first and second respondents to his traditional wedding is one that leads to the perception of bias. Due to the failure to so disclose on the part of the third respondent, it has led to an erosion of the confidence that applicants have that he will be neutral when it comes to the hearing and determination of the arbitral proceedings before him involving the parties hearing. In conclusion, this court holds that there was lack of transparency on the part of the third respondent, and he should have done the honorable thing when he was requested through an application to challenge to recuse himself from the arbitral proceedings in nature. This court finds that the justifiable doubts have risen as the third respondent's impartiality and independence, and the same have been proved by the applicants. This is a decision, and the only one we could find that addresses on all fours the issue that confronts this court. I ask this court to find favor with this decision, to recuse itself, and I do so with tremendous respect. It's just that the nature of the matter, the nature of the issues, and the perception are such as are captured in that decision. Recusal would be the only thing that would do justice to not only the applicant before you, but to the court itself. Thank you for the privilege of your attention, for your time. Unless you have any questions, I'll rest at that point. You have it. I sent it, soft copy, you have.
Yes. My Lord, it is my humble submission that your lordships must exercise flexibility. The usual case law relating to recusal is inapplicable in the instant case. As a matter of fact, if I say to you very respectfully, if there are parties, and indeed there are, who do not want or who do not wish to see you hear this matter, please walk out. You are not the only judges in the country at all. Let another panel of judges be appointed to hear this matter. My Lord, if I may say so very respectfully, to refer to my own history. When you reach my age, you keep on looking at your history. I remember there were one or two expatriate judges, colonial judges. The moment you said to him, to him, but your lordship, I would like you not to hear this matter. I want you to recuse yourself. His response was, okay, if you don't want me to hear this case, let another judge hear it. That is the attitude you should take. Those of us who have had the advantage of receiving higher education know when you're dealing introduction to philosophy, you are taught that perception, the first course you take is perception and reality. Perception and reality. When you're studying philosophy, perception is a very important concept when it comes to the arena of politics. Reality may be completely different. And indeed, I believe it is different in the case before your lordships. I appear before you very often. I've never entertained any idea about your standing in relation to justice. But the perception now that has been painted by my able, learned friends, clients, Mr. Ndegwanjiru, Mr. Kibe, and Mr. Macharia, that there is a sizable portion of the Kenyan population which will not be happy to hear you sit and listen to this case at all. And may I remind your lordships very respectfully, impeachment is politics of the country. There's no way you can move away from that at all. I would respectfully refer you to a book I've taken the trouble to read.
Your Honor, sorry for the interruption. We are muted again. Perhaps you could be unmuted so that we follow the proceedings.
I wonder why it has happened in respect of Hamino. Can I speak now? Can I speak?
Yes, sir. You've not been muted.
Yeah.
Yes. Your Honor, there is a book here, Politics of Presidential Impeachment. Politics of Presidential Impeachment. I've taken the trouble during the weekends to read this book. Impeachment is politics of the country. There is no way you can remove it from the politics of the country at all. And that's why I'm saying, Your Lordship, very respectfully, that as you have been told, there are some people who feel very strongly that you should not hear this case. Get out. Let them get other judges to hear the case. You have no vested interest in the matter. There's no reason for you to remain in the case when other people do not want you to hear the case at all. May I remind you, my lords, when you are hearing impeachment cases, advocates should be able to think broadly and bring to your notice the culture of the people that you are serving. There is a little song there's a song that is sung by a little girl in Kenya. To those of us who listen to the Kenyan radio may have heard of it. He says in Kiswahili, Kenya ni nchi ya watu akili kidogo. He sings very beautifully. Kenya ni nchi ya watu kidogo. Na wanataka kitu kidogo ndio wafanye kitu. Majority of our people are not the people who are in this courtroom at all. The majority of our people are people who have not had the advantage of receiving the education, the training that the judges and the advocates and the members who are in this room at all. And as one of my learned friends very ably pointed out, majority of the people believe that the case before you has been engineered by the politics of the country. Indeed, if some of them believe that your lordships cannot hear them, again, I say to you very, very respectfully, you stand to lose nothing. You better leave the case, let other people hear the case, and you will continue to maintain your name. My lords, to go back to the politics of impeachment, this matter was first heard in the National Assembly. The National Assembly very overwhelmingly stated that the Deputy President had been impeached. It was then referred to the Senate, and the Senate again stated very overwhelmingly that the Deputy President was guilty and convicted him accordingly. My lords, the stories that one hears in the streets of Nairobi, the stories that one hears elsewhere, you cannot afford to ignore it. Stories like members of parliament were each given a handsome amount of money. That may be so or may not be so. It doesn't matter. They have made their point that the members of parliament received bribes and they handed down a decision which majority of people believe that it was a corrupt decision. You cannot afford to ignore that. Now, when you go to the Senate, you are told the same thing, that the members of the Senate received money in what is called is it white Bahasha or something of the sort, white Bahasha, they received money from known people. Again, you cannot afford to ignore that at all. Now, when they come to the judiciary, they expect the best. They expect people who have got integrity. They expect people who can hear them and whom they cannot suspect at all. But if then they are suspecting some people, whether truthfully, whether honestly or not, it is my humble submission, the natural thing as a judge, if I was sitting where your lordships are sitting, I would say, as Khaminwa, I'm walking out. Do not sit. It is the judiciary that people have got confidence in. And if I may remind you, your lordships, very respectfully, it is the judiciary that people of Kenya actually have respect for. It is the judiciary, the judges, that people think that can do good in Kenya. When we had a problem in the year 2007, it is the judiciary that saved the country. When we had a problem recently during the time of President Uhuru Kenyatta, and the matter went to the Supreme Court, it is again the judiciary that saved the country. Now, if you find that people now are questioning the very institution of the judiciary, it is my humble submission that as a judge, move out. Say thank you, I'm moving out. That does not necessarily mean that there is something wrong with you at all. And as I've said, my lords, I've spent many years appearing before your lordship, Mr. Justice Ogola, in Mombasa. At no time did anybody ever open his mouth and say to me that, Khaminwa, this Justice Ogola is this, is this, is this, is this. Nobody ever did it. My Lord, Mr. Justice Murima, I've had the privilege of appearing before you in many cases. There are cases where you have given me rulings. There are cases where you have not given me orders at all. But at no stage did I ever entertain an idea that there's something wrong with Justice Murima. We have confidence in all of you. But now we have this concept of perception. There are some people who feel very strongly that Justice Ogola should be out. Justice Murima should be out. My lady judge, may I say I'm leading you, I'm not discriminating against you. I'm one who has fought for rights of women. And I kept on shouting very loudly that we want women judges. I have not had the fortune of appearing before you very often.
Actually, you have on a couple of times.
Sorry, my memory is letting me down because of it. Yes. But my lords, may I say, I have had the opportunity of appearing before you. And may I say this, my lords, if you go and check Judicial Service Commission records, you will not find a single letter from John Khaminwa complaining against any judge. I have never done such a thing at all. It's because I've got confidence in our judges. I've got confidence in our magistrates that they deliver justice. But I'm just saying you, my lords and my lady, if at this time we have some people who feel very strongly in the camp because that they may not get justice before you at all, please walk out. Don't continue to hear the case. And indeed, the people who are saying that your lordships or my lady should not hear this case, when they are speaking, you cannot really criticize them. They have got some valid complaints. My lords, United States of America, which I had the opportunity and the privilege of getting and studying their jurisprudence, they gave me additional legal education. United States of America, which has an impeachment provisions like Kenya, for 200 years, there is no president or deputy president who has been impeached, and the impeachment has succeeded. None at all. None at all. Kenya, a young country which got the first constitution involving impeachment provisions, came into operation in 2010, and in 2024, we are now being told the deputy president has been impeached successfully, has been found guilty. Is it unreasonable to suspect there is something wrong? Is it unreasonable to suspect that someone is doing something wrong? Gachagua may be a nut, may not be probably properly educated, but he's a deputy president of the Republic of Kenya. Why should he be the first one within such a short time to be impeached in the country? Can't you suspect there is something wrong, that you are not doing some things properly? That America, which has had impeachment provisions for 200 years, has never successfully convicted someone for impeachment at all, a politician.
Thank you, Dr. Kabinwa. Thank you very much.
My Lord, may I say thank you, but may I say with your respect, I would appreciate if you would uphold my submissions. Thank you.
Just 2 minutes, my lords. In considering this application for recusal, I plead that you bear in mind the following. One, your brother, Mr. Justice Chacha Mwita, your brother, Mr. Justice Mugambi, your brother, Mr. Justice Mwongo, sitting separately, each one of them was persuaded that the petitions and the notices of motion asking for conservatory orders raised weighty constitutional issues. That is why this bench was constituted. Those weighty issues await full arguments by both sides for the court to resolve. Number two, the weighty issues are around the petitioner applicant, the deputy president, challenging and seeking to have the impeachment quashed. In the interest of time, I will not restate those weighty issues. They are in the record before me, but they are there. Challenging the impeachment and seeking to have the impeachment quashed. For the sake of this country, today and going forward, those are issues that must be heard and adjudicated by a bench that has no issues of bias, apparent or real, being raised against it. So for that reason alone, please accede to recusing yourselves so that another bench can be set up to adjudicate those issues. I thank
you. Very briefly, Your Lordship. My name is Gachagua. I would like to talk about just 3 aspects on the subject of recusal, and I'll be making reference to 3 materials I believe they've been circulated. That's a recent Supreme Court decision
delivered on 11th of October 2024. Let me make arrangements so that they are brought the copies. Yeah. Your Lordship, on my right and on my left are counsel who are involved in this matter where the Supreme Court was asked to recuse itself.
Which case?
This is Dari Limited and 5 others versus East African Development Bank. Mr. Nyamondi and Senior Counsel Paul Mito were on the same side, but today they are on different sides of that decision. When that application was made before the Supreme Court, I do not want to go through all what went on. I want to go straight to paragraph 27, where the court said, having arrived at the inescapable conclusion that we are being accused of bias and working towards an undisclosed predetermined outcome, we are strongly persuaded that our further participation in these proceedings will not serve the ends of justice, at least in the eyes and perception of the appellants / applicants. Consequently, and inevitably, each of us on this bench does hereby recuse him or herself from further participation in the hearing and determination of the appeal dated 25th April 2023 and filed on 26th April 2023. That's a decision that was made just when these petitions were ongoing. So when allegations of bias and working towards a certain outcome are made, for the Supreme Court recently is it recused itself. My Lord, I have a decision, an Indian decision. It's called State of Punjab versus Davida Pal Singh, which also the question of recusal was discussed at length. And again, I do not want to dwell. The whole decision is a very lengthy one. It's about 400 pages. But at page 9, at paragraph 16, the court set the standard that is applied in determining whether a bench should recuse itself. And the test, I read, the test of real likelihood of bias is whether a reasonable person in possession of relevant information would have thought that bias was likely, and whether the adjudicator was likely to be disposed to decide the matter only in a particular way. The court went on to say, the court has to proceed observing the minimal requirements of natural justice, i.e., the judge has to act fairly and without bias and in good faith. A judgment which is the result of bias or want of impartiality is a nullity, and the trial coram non judice. Therefore, the consequential order, if any, is liable to be quashed. Lastly, and this is what is very important, at paragraph 18, the court said in part, however, if there is real ground for doubt, that doubt must be resolved in favor of recusal. So that, my lords and my lady, if you are in doubt whether you should recuse yourself or you should not recuse yourself, that doubt should weigh towards recusal. That decision will be shared. And then the court went on to quash some proceedings which had taken place, an appeal had been determined, and then this one went all the way to the Supreme Court of India. So the court said that that is how situations of bias are treated. I had reference to the code of conduct of judicial officers. I think that's what Mr. Dego was referring to. My Lord, I want to lay the basis as to where those provisions are obtained from. And those provisions are obtained from the IBA guidelines on conflict of interest in international arbitration. You will find that material is published by the I located it from the International Bar Association, and it was done first in the year 2004, and it has been applied worldwide as a guide on determining situations of conflict of interest. And it has graded conflicts in several shades, the traffic light shades. There's green, there's brown, and there's the waivable, non-waivable, waivable, green, and the brown. And at clause 2.37, one of the situations that is a waivable conflict is the arbitrator has a close family relationship with one of the parties, or with a manager, director, or member of the supervisory board, or any person having a controlling influence in one of the parties, or an affiliate of one of the parties, or with counsel representing a party. Going with the materials, if they are true, that was stated by my learned friends, then that situation has already arisen, and therefore it is a good ground for recusal. But I don't want to take much more time, but these materials will be circulated. There is much more in these materials that speak towards recusal in the situation that is now before. Thank you very much, Mr. President.
Sorry, Counsel, does the court have the benefit of the authority that you have referred to, the Punjab case and the IBA guidelines?
The Indian and the Supreme Court case?
Yes, and the IBA guidelines, have you supplied?
They are being brought attention. Yeah, thank you.
How many more?
I wish to say something on behalf of the second petitioner in 565. If I'm allowed to proceed.
Who are you?
Can you see me?
Your name?
I'm virtual. I'm online.
What is your name? What is your name?
Kimodo Teresia Wanjiro Makazi from Kilgoya.
Yes, proceed.
Yes, thank you. I just wished to support that application by just submitting that public perception is everything and it cannot be ignored. I wish to rely on Article 47(1) and Article 50, and more specifically in Article 47(1) is where it says that every person has the right to administrative action that is expeditious, efficient, lawful, reasonable, and procedurally fair. And more specifically on the part that is procedurally fair. Yeah, if you look at the way the court has conducted itself, of course we are in no doubt that the court is competent enough to handle these petitions, but then again, on the issue of the procedure, we had raised an issue of service, and the court ruled that we should check all documents in the portal. Unfortunately, today, you could not access the e-filing portal. So what one is meant to wonder is why we were told to access documents online, and when we go to the portal today morning, it's not working. Therefore, there is this perception that perhaps there could be something going on, because at all material times, judges shall be impartial. And the issues being raised currently are that there is an issue. Sorry? Okay. So there are issues that are being raised that are raising issues to conflict of interest, whereby we have been directed by the applicants to note that one of the judge has a spouse who has been nominated or appointed by the President of Kenya, His Excellency William RUTO. And I think that is not a question where we should be giving out affidavits. I think that is a question where the judge, the honorable judge, should just come out and tell us, if this is true, then are you going to feel conflicted? So that we can, as petitioner, say, okay, proceed, or no, let's have a neutral bench. The other issue is the issue of another judge, Honorable Justice Murima, being seen. No, not the judge. I'm not saying the judge. I'm saying the spouse of the judge being appointed. That's the issue that has been raised by the applicants. And so we feel, of course, if this appointment was done, will he be able to Rima attending a wedding ceremony, Kingi? So the issue is, and they are long-time friends, will he be able to disappoint a friend? You know, these are the issues that the public is asking, and it's the perception anyway. So in issues such as this, we say these issues are very important and they cannot be ignored. And there's no point of, if people are saying we don't want the bench, it's not so hard for the bench to say, okay, just let's go back to the Chief Justice, please appoint another bench. There's nothing wrong with that. We know the judges are competent enough, but then if the issue of conflict of interest is arising, then the best thing to do before we go to the substantive issues is to pen everything down and say that go back to the drawing board and appoint a new bench. That's all.
Yeah, please, Your Lordship. My name is Daniel Manzo. I do appear for the third interested party, Wiper Democratic Movement Party, together with Mr. Kala. My Lord, I want to say only one short thing and then allow Mr. Kala to conclude without repeating what has been said this afternoon. My Lord, in 2008, I was involved in a matter which touched the Vice President of the country. I appeared before Justice Paul Kehati, and he immediately told me the second respondent is my personal friend, was my classmate in law school. I recused myself. I was sent to Justice Wendy. I appeared before her, and my Lord, she said, the first applicant, a renowned professor, is my personal friend, and I recused myself. My Lord, I ended up in an out-of-court settlement. I do ask Mr. Kala to conclude.
My lords, my lady, I just make one submission that in light of the disclosure about the relationship between Justice Murima and the Speaker of the Senate, we find ourselves in a very unfortunate situation where the bench looks like it's on trial. Motions of recusal are normally very difficult to prosecute because the question is, and this is a question that respectfully I want to pose to the bench. Do you will you feel comfortable? Do you appreciate the fact that so far the events that have taken place, whatever determinations that you will arrive in these particular matters, and they are weighty constitutional national matters that affect the entire country, are you satisfied that they will be received well by the public? That's a question that should be in the mind of the judges as they decide whether to recuse themselves or not. Secondly, it is very clear that the only mistake here was that Justice Murima did not disclose a relationship between himself and Amason King, which is out of a friendship and which is not even illegal. But disclosure, the mere fact that there was no disclosure by itself creates suspicion, apprehension in the minds of the applicants. The last question is, if Justice Murima decides to recuse himself, is it the entire bench that will recuse itself, or only one judge will recuse himself? Because I'm convinced that inevitably Justice Murima must recuse himself. Thank you so much.
Your Lordship and my lady, if it may please you, my name is Hakim Park. I do appear for the third petitioner in the consolidated petition. Your Lordship, mine is just to put into context the Supreme Court decision in Dari and 5 others versus East African Development Bank. So, Your Lordship, in that particular matter, I want to say that, first of all, it was before the Supreme Court, and notwithstanding the doctrine of necessity, the Supreme Court considered that the right to a fair hearing by an impartial tribunal was so sacrosanct that the Supreme Court did not even consider the doctrine of necessity. So I just want to read paragraph 26 where the Supreme Court said, what is undeniable is the fact that by resorting to this course of action, the applicants are unequivocally accusing this bench of lack of impartiality, fairness, and integrity. Such an accusation against a judge goes to the very core of his oath of office. Coming from a party to ongoing proceedings, such an allegation must strongly persuade the judge to recuse themselves. So that is what the Supreme Court said. So, Your Lordship, in that particular paragraph, the Supreme Court is saying that if there is an allegation, especially because this instance is actually almost same to that, because there was a complaint that was lodged against that bench before the Judicial Service Commission. I have heard today that the first petitioner has already lodged a petition before the Judicial Service Commission. Your Lordship, I beg that you are guided by this decision in holding that the right to a fair and impartial tribunal is very key.
Thank you, but I think you should let us know about the petition which has been lodged, because I don't think parties are aware of that.
Your Lordship, I think it is in the further affidavit.
A petition?
No, not petition.
What is it?
A complaint that was made.
Don't mislead the public. There's there's a whole difference between a complaint and a petition.
Yes.
Don't mislead the public.
He is the one who has said petition. He said complaint.
All right.
Yes. Thank you.
He's on our side.
Where are you interpreting?
May it please the court. My name is Dr. Eboso. I'm from Vihiga County, and I'm petitioner number 11 in the consolidated petition in the cohort 1. As I sat as a petitioner who essentially had no issue with the sitting of the bench, because when a petitioner files a petition, there is a presumption that the bench is properly constituted, and that Kenyans elected the Constitution of 2010, and in it provided the independence of the judiciary and the conduct of the expected conduct of judges. And therefore, we as Kenyans have trust in the judiciary and the individual judges at the time when they are appointed and during the course of their performance of functions. But as I sat, I agonized over the issues that have been raised, and as a at the outset, I realized that the recusal application has been made to this bench to recuse itself, or some of the judges to recuse themselves, but as a decision of the bench. And I agonized over whether recusal or the place of recusal proceedings in a setup like ours. And perhaps this was amplified by the back and forth that we saw with regard to the facts that were coming out. And I would wish to be persuaded by Dr. Haminwa that really recusal proceedings and the kind of facts that come to light ought not really be a subject of litigation for several reasons. One, recusal proceedings are really against individual justices, and they relate to the personal conduct which really lies in the mind and conscience of the individual judge. I would give an example. Suppose we ask the bench for one of the judges to recuse themselves, and two of the justices disagreed with the recusal, but the very judge who we are asking to recuse themselves. Would we then say that this bench has ruled that the judge must sit? So it's really an individual decision of the judge to reflect upon the facts that are before him, the relationship, why it can't be litigation, and it should be in the interest of all the parties that the judge is not biased, such that when you make it litigious, what happens is one side will be claiming the other side must prove a point, which they are not really very materially cognizant of. And it's really just the judge who knows the actual facts of the issue. And so it really is upon the judge individually to look at themselves and ask themselves whether the facts that are being alleged constitute what would amount to a bias. And when we make it litigious like this, we actually violate the Constitution, for the reason that the conduct of a judge is not meant to be subject of any proceeding before a court. That is a matter that should be before JSC, that should be before other tribunals. And the Supreme Court has told us that in Bellevue, that the conduct of a judge, because that's what is being alleged here, a judge is being alleged to have concealed information that they ought to have given. A judge is being alleged to have abused office by sitting on a particular day and whatnot. So those are things that really should not be a subject of a proceeding if we really intend to proceed with this matter. Suppose this bench does not recuse itself, then how does the matter proceed in that manner? I'd like to point out that I think I've already talked about the fact that the facts relating to a recusal, the person who really knows what those facts are and the extent to which they are is the judge. And so any discussion as to whether we've proved a case or not proved a case is neither here nor there as relates to this issue. I'd like to refer the court, I don't know how we quote precedents, but I'd like to refer the court to a decision of the Supreme Court of the United States in Jewel Ridge Coal Corporation versus local number 6167 United Mine Workers of America in 1945. And there the court, the Supreme Court, found that I think one of the parties was asking for the entire bench to recuse themselves. And I'll just take maybe one more minute for the entire bench to recuse themselves. And the Supreme Court of the United States found that that decision cannot be made by the bench. A question of recusal should be directed at the judge, and it should be the judge to make the decision whether they themselves will recuse themselves or not. It was also, again, captured in 1980 in a decision called Hanrahan versus Hampton, still at the United States Supreme Court. And in India, in 2016, Advocates on Record Association and others versus Union of India, Justice Madan also pointed out the same. And finally, I'd like to refer the court to the fact that this is a sensitive matter, but it's also, as sensitive as it is also an urgent matter, as considered by the bench and as considered by everyone. That there is aspect of necessity that this matter must be heard. And there's also room for appeal should any person feel they are aggrieved by decisions of this court or the judges herein. And so what I would say is that I would ask that the individual justices that you look into the issues that have been raised, you look into the facts which you are familiar with them yourselves, and go home and reflect whether indeed you will have the impartiality to hear this matter. And once you make that decision, let's hear the matter and proceed. Thank you.
My lords and my lady doctor, if it pleases you in the matter, my name is Wamboi, Shadrach Wamboi. I speak with the blessings of my senior, Mr. Danstan Omari and Samson Nyaberi, on behalf of the 9th petitioner. My lord, at the very outset, permit me to submit that this court has a duty, either individually or as a collegial bench, to hear and determine the matters that are presented before court. Indeed, just like any other person, you have a duty to act in the defense of the Constitution. However, matters that relate to the calling to question of the conduct or the integrity of the bench or a judge are matters that are characterized in this country with a lot of rage, as we have even seen being demonstrated in this honorable court. In other occasions, applications for recusal, my lady and my lords, are said to be a dialogue of the deaf and a dance of the blind, to the extent that the petitioners or the applicants making an application such as the one that finds itself before you sometimes refrain from even saying the very grounds upon which they make the application, as you have seen before this court. And again, the bench on the other end, on many occasions, tends to draw conclusions of what they would think the applicant is saying about their conduct or their integrity. So for that reason, my lady and my lords, the court is then called upon to reflect as to its duty to do that which is just vis-a-vis the perception, either actual or apparent, that will flow or be submitted by applicants who call to question the conduct of the court. My lady and my lords, permit me to also make a contribution with regards to the decision that has been made in the Supreme Court case of Dari Limited. And there is something that is important that we must highlight. In this application, the Supreme Court was not called upon to adjudicate on an application for the recusal of the court. That was not the application that was lying before court. What is important that we must underscore in this case is that the court was invited to suspend or stay its proceedings in view of a complaint that had been made by the applicants before the Judicial Service Commission, so that the court ultimately ended up recusing itself, not that it had been invited to recuse itself, but because there had been a complaint that had been filed before the Judicial Service Commission. My lady and my lords, the reason why the 9th petitioner rises in support of the submissions made by counsels who have made the application is largely due to our duty as the officers of the court. And we have seen in the application in petition number E015 of 2024, annexure marked DMM2, which is a letter addressed to my colleague Mr. Swanya of Swanya and Company Advocates from the Judicial Service Commission, highlighting a complaint that has been made by the Deputy President of the Republic of Kenya, His Excellency Gachagua, against this honorable bench. So, my lady and my lords, as I rest, the question that begs the answer is simple. If a complaint has already been lodged against the persons of this honorable court, how will a reasonable person, or will a reasonable person out there be confident that this court, in light of the complaint that has been lodged against you by one of the petitioners, arrive at a just finding in this case? My lady and my lords, that should mark the end of my submissions. I shall pave the floor for the remaining minutes to my seniors to also speak some wisdom to what is in issue. Thank you.
My lady and my lords, my name is Sam Nyaberi, for the 9th petitioner in the 2nd cohort. I stand in support of the motion for recusal, and I juxtapose it in this manner. Recusal applications are tantamount to the court being on trial. It's a charge sheet for the court that it then will determine the parameters that have been set and the grounds that have been adduced to find or make a finding whether they merit. And in so doing, the court will not be given an opportunity to make submissions as we are doing. It's the court that is going to now render a ruling. Then the big question that we ought to ask ourselves, whether then the court is going to rebut on the heavy submissions that have been made, because going into the second room of going to analyze what the petition is all about will mean that we as the petitioners will have faith in even opening the second chapter of the proceedings as they are going to happen. So therefore, my lord and my lady, the point we are making is, kindly, there is enough evidence that has been laid before you to make a determination that indeed it is not available for the court to open the second chapter of going into the determination of the petition. I rest my case there. The balance of my time, I invite Romari to finish up and conclude.
My lords and my lady, I'll be very, very brief. One, the court, in determining whether the DCJ has powers to constitute a bench, made a finding that the petitioner was found guilty of an offense of addressing the gallery. His lawyers, all of them, never addressed the court. The lawyers were not addressing you. It is the petitioner who was addressing you. You have already made a decision that the petitioner was addressing the gallery. Will he have confidence to appear before you? Ahmed Nasir Sr., when he was constantly spotted by the Supreme Court that he was attacking the courts, the court decided to punish. When he appeared, all the members of the Supreme Court recused themselves. They never gave him audience. Will the deputy president have audience before you when the main substantive motion comes before you? You have already made up that his job is to address the public. The rationale for this matter, going live and my brothers and sisters saying it's a public interest matter, is because 55 million Kenyans are waiting to see the free learned judges appear impartial. It is our submission from our client Sharia Mutani that based on that you recuse yourself. I'll give a small analogy. When I went to pay dowry for a friend of mine, we were told that that place, those people were witches. So that religion, when food is being prayed for, you must close your eyes. We never closed our eyes because behind us we feared, my Lord,
and my lady that these guys might destroy us. The petitioner is scared of this page. That's my lord.
I withdrew with all parties supporting the application. In that case, Professor, you can continue.
I thank you, my lord, and members of the bench. I will try to be brief. My colleagues and I, I think, would like to be truthful. First, we would like to begin by observing that today is the 10th day since this bench was constituted. It was constituted on the 14th of October. There were petition 522, petition 550, petition 569. Nobody ever complained at all until we came here on Monday. And even then, the complaint was an ambush. The petitioners appeared before my Lord Judge Ogola on the 16th of October. Orders were made in their favor. They were extremely happy. No complaint. The three judges of this bench were in the bench in 522 of 2024. No complaint. This complaint is a complaint founded on the fact that on the 18th, the Honorable the Attorney General, for the first time, also got orders. Now, that is when this bench became a bad bench. It was a very good bench for as long as it gave any order to the petitioners. It became a suspicious bench when it gave an order, only an order to expedite the hearing. The Attorney General had wanted many things. They were all declined. I will address you, my lords, on the understanding that we have two petitions. There's one petition I call the Kerugoya petition. And there is another petition I will call the Nairobi petition. It is our preliminary submission that yesterday's ruling of the 23rd substantially addresses the issues raised in the Kerugoya petition, and that those issues are now the res judicata. There is issue estoppel. There is issue estoppel, a doctrine of law that states a question that has been resolved by the court cannot be litigated afresh in the same proceedings. It is our second submission that the first limb of the Nairobi petition on recusal that speaks to how the case was handled between the 18th and the 22nd is also substantially settled by yesterday's ruling. And I think my learned friends, most of them, were able to confirm that. And they complained about that.
No.
So what issue is alive? The only issue that is alive is the issue of recusal, allegedly on the grounds that I'm so happy that my lady has been spared any further unwarranted attack as regarding her standing So I will not make any reference to that. It has been considered that it was made recklessly, without any factual basis. And I think that what an ethical advocate of the Honorable Court should do is to start by saying, I apologize to her leadership for these allegations that are contained in a document that bears my signature. But that is not for me to say. So let us proceed to the two other allegations. At one point, I was very surprised to hear a submission that said that my Lord Justice Ogola is close to his wife. How can that be? How can that possibly be a bad thing? But a further extension of that argument was equally spurious. A professional person is entitled to an independent professional existence. Be it the husband, be it the wife, be it siblings, be it children, they have independent professional. And I am shocked that that can be a ground. Another ground now made is that the Honorable Justice Murima is a friend of the Speaker of the House. The Speaker of the House was my student. I don't know whether I should recuse myself. My Lord, if I may say this with respect, I have been a law teacher for 38 years. I apologize that that's not very long. There, 3/4 of the lawyers under the age of 50, I have taught them. I don't know whether I should recuse myself each time I appear against, including the Honorable Tom Ojienda here, Senator. Could you confirm that?
I confirm that you're my teacher.
Yes. And George Gorogaru, Senator, the Solicitor General, the Attorney General. This is the nature of our profession. This is the nature of our profession. The Speaker is a member of the legal profession. The Honorable Justice Murima is a member of the legal profession. How else are we to do our work? Paul Kibugi Muite, Senior Counsel, a personal friend for many years. On the day I got married, he brought me a copper coffee dispenser. Am I never to do any case with him? Should I always tell people, I know Paul Muite from when I was mayor, he came to my wedding, he brought me a gift. It cannot possibly be. That is not how this profession works. Let me very quickly set this, what we believe is the standard. The standard is set in the case of the most important of this all is the Rai case, which has been talked about. When will you ask for a recusal? And I agree with Dr. Kamino when he says that no lawyer, no advocate should ever make an application for recusal lightly. Indeed, an advocate approached by a client who is making personal attacks against a judge that are baseless must return the brief to the client. That is the honorable thing to do. Now, I have referred you to the Rai case, but the most important of this all is the objective test that is set in the Rawal case. In the Rawal case, which you are aware of, Rawal versus Judicial Service Commission, the court says there is no basis for a judge to automatically recuse themselves when a bare allegation is made by a party. The allegation must be substantiated. First, they now quote the Court of Appeal. Firstly, it is obvious from the above test that there is no basis for the lather elastic test propounded by Dr. Kaminwa. where a judge must automatically recuse himself or herself upon the making of a bare allegation of any of the parties. We have not come across any authority in support of the proposition, and Dr. John Kaminwa did not provide any. On the contrary, decisions abound that judges must not recuse themselves on flimsy and baseless allegations. It is our submission that a claim that the friendship that may exist between a party and a judge because they went to the same school, because they went to the same university, because they come from the same county, that is baseless. It must be demonstrated, like was said in the case of Kaplan and Stratton versus Z Engineering Construction Limited. If disqualifications issues were to be raised, say, because a judge and a member of the bar belong to the same Rotary Club or the same Lions Club or the same sports club, there would be no end to such approaches. There would be no end. In this case, it has not been demonstrated that there is any way in which the independence of any of the judges here can be said to have been compromised. Let me say something relating to the Dari case, because I was involved in that case, again with my very good friend, the Honorable P.K. Moite, on one side, and my friend Paul Nyamodi. They were on one side, I was on the other side. I think that's why Mr. Nyamodi has now come back to my side, because we were the successful party in that case. And as one of my learned juniors here on the opposite side has stated, you need to understand the context of the Dari case, because at paragraph 24, the court states this: the appellants applicants herein are seeking a stay order from this court in the most unusual, strange, and dare we say disingenuous strategy. What had they done, my learned friends? We had litigated for a very long time. Litigated in England in the High Court, litigated in England in the Court of Appeal, litigated in the High Court here, litigated in the Court of Appeal here, litigated in the Supreme Court, and their final card, they had made a complaint against the Supreme Court. And what they were asking the Supreme Court to do is stay proceedings as we go to prosecute the allegations we've made against you. And I think the Supreme Court threw the sink at them. And that is why the decision says what it says. Now, I want to wind up by saying that if this court were to accede to this application, it would throw into disarray a critical public interest litigation when the country is in the throes of a serious constitutional crisis. And that is why philosophers like Dr. Muthomi say that cities burn as philosophers are quibbling on whether we need a bucket or a pipe to put out the fire. We are in the throes of a grave constitutional crisis. The court that we have been given to resolve this issue cannot stop sitting on the basis of the most flimsy allegations of friendship between parties, because I don't know of a single representation here that is not related to another. If you opened this door, you will have created a precedent where all a lawyer needs to do, an advocate, all he needs to do is to make a connection. To make a connection. You go to the same church, you go to the same mosque, you used to work in the same chambers, you were trained by the same pupil master. Our connections will never see. Like they say about taught actions, there can never be an end to taught actions, and there can never be an end to the relationships we have in the legal profession. An applicant must demonstrate that because of that relationship, there is reason to believe, demonstrated by either past behavior, past judgment, past ruling, past conduct, that a judge will be biased in any way. But ultimately, as the authorities I have cited to you state, a judge has taken a judicial oath. A judge has a judicial oath. He answers to his conscience and to his oath. And finally, I will say, because I've had the great privilege to sit as an arbitrator in numerous matters, both locally and overseas, I have never found a standard that requires that if a person who has a historical connection with somebody, without demonstrating more than that, can be the basis of recusal. I will now hand over, before Madam Timekeeper asks me to my learned friend, Mr. Gould.
My lords and my ladies, for completeness of our record, we have filed grounds of opposition. We also have filed a list and bundle of authorities, all dated the 22nd of October 2024. My lords and my lady, permit me to start by saying that judges, just like they sit to determine disputes between parties who come before them. That is what makes us a country governed by the rule of law. In that duty, my lords and my lady, it is important that we ensure there is efficiency in the conduct of that very important responsibility. That is on the one hand. On the other hand, it is important that judges then guard against manipulation of processes. In the context of what we have, proceedings like we have today, the manipulation of process could manifest itself in the form of forum shopping, where we say that I will file this matter before this court, and before this court. In my hope, one of them will give. And that if I run into headwinds in any particular direction, then I must, as of necessity, run away from that court. My lords and my lady, this is a position that has been adjudicated, the fact that the court has a duty to sit, all the way to our Supreme Court. We have in our list and bundle of authorities provided or cited one of the cases as being a case of Gladys Beausoleil versus Judicial Service Commission and a second party. At paragraph 5 of that decision, the court says that the doctrine of duty of a judge to sit, though not profound in Kenya's jurisdiction, then there's, I think, a spelling mistake. Every judge has a duty to sit in a matter which they should duly sit in. Recusal should not be used to cripple a judge from sitting or to hear a matter. That duty to sit was buttressed by the fact that every judge took an oath of office to serve impartially and protect, administer, and defend the Constitution. In yet another decision, Peter Mwangi Gishuru versus the Attorney General and the Salaries and Remuneration Commission, at paragraph 61 of that decision, the court says, the court has a duty to sit on matters presented before it for resolution and should only recuse itself where circumstances permit, but not where it will create an unconstitutional moment by refusing to hear a litigant's case because the opposite party apprehends bias. In what context then should we understand that jurisprudence? My lords and my lady, it must not be lost on us that when we are dealing with momentous topical issues of conversation in a country such as Kenya, like what we are dealing with, these matters evoke emotions. Just like in our election context, whenever a party loses, it is never so easy to accept the result of that loss. It is for that reason that sometimes people have all manner of aspersions cast against the court, against the independent, let's call it all other independent organs of the Constitution, because a decision has gone one way or the other, in instances not favorable to one party and favorable to another. We must appreciate that we are in an adversarial system where, as of necessity, a decision will be determined or will be made in favor of one party as against the other. That said, my lords and my lady, learned senior counsel Professor Githu Muigai has made reference to the fact that the matter that is before you, though dubbed as recusal, is a matter whose subject matter has been completely determined. There is issue estoppel, and that everything that has been presented before you today are issues that were contained in the ruling that your lordships issued yesterday. As a starting point, I would make reference, my lords and my lady, to the application that was filed yesterday by our opponents. The application seeking to have questioning the empanelment of this bench. If you look at paragraph Y of that application, on the grounds on the face of the application, my lords and my lady, the court was invited particularly to recuse itself. It then means that that motion for recusal was a motion that was live before this court. That motion was live between the same parties. It touched on the same issues that were presented before this court. The court pronounced itself on all those issues. What then is the business of bringing those issues through this second court application in the name of an application for recusal? My lords and my lady, if at all, as we now see, the applicants were not satisfied with that decision, the ruling of this court, the option that was available for them was to appeal that decision. Presenting this second application does not in any way open for them a door other than for purposes of delaying these proceedings. And I would say that with tremendous respect to my learned friends from the other side, and so that I am able to demonstrate, permit me to just look at the applications that have been filed and the issues that have been raised in those applications. I'll start with the application filed by my good friend, Dr. Evans Ogada. In his application dated the 21st of October 2024, he raises as ground number 1 the issues of a certification of these matters on the 18th of October. That was an issue that was before you yesterday. At paragraph 3, so that we understand context, he also says that on the next day, being Saturday 19th October 2024, the petitioners were surprised by the turn of events wherein they were served with an order of this honorable bench stating that the first and sixth respondents' applications dated 18th October 2024 was coming up for inter-parties hearing. Again, that was an issue that was before you. At paragraph 4, it talks about the subsequent reference of the matter by the Chief Justice to the Chief Justice on the 18th of October. That was an issue that was before you. Finally, he questions the unclear circumstances that led to the placement of the file of this bench on a Saturday before you without the express directions of a Chief Justice. Again, my lords and my ladies, that was a matter that was before you. In the application by Mr. Njiru Ndegwa, again, the same thing. First ground, that the petitioners have learned that this bench sat on a Saturday, the 19th of October 2024. That was an issue that was before you. Paragraph 2, it says that the petitioners were surprised by the sudden turn of events. Again, the same language used by the other application. In the other application, a matter that was before you. Paragraph 6, it says that the petitioners are apprehensive that this honorable court has clearly demonstrated that the case for the Attorney General is more important than our petition, yet they are raising similar issues. Again, that issue was before you, and it was determined. Paragraph 8. Let me stop first there. How then do we treat all those issues that were before you? And if we're, just so that then we understand that these matters were before you, when you delivered your ruling, which was shared with us this afternoon, from paragraph 73 all the way to paragraph 96, each and every of these issues were responded to. I mean, determinations were made. At paragraph 79, for instance, the court says, but backed by this sequence of events, we take great exception to the petitioner's conduct that when favorable to the petitioners, orders issued outside the normal working hours of a court raise no concern. However, when the same court acts in an instance where it has been properly moved by the other parties and likewise proceeds to deal with an application at hand in the same vein, the petitioners show their indignation. That was a finding that was made. At paragraph 96, you even go further to say that one of the senior counsels went further by intimating that an exercise akin to the radical surgery may be forthcoming, a statement which we perceive as a veiled attempt at intimidating, intimidation coming from senior counsel. My lords and my ladies, what is left that you're supposed to determine again? It is an attempt to have a second bite at that which has already sailed. If for one moment we were to look at this application by Mr. Ndegwa Njiru, he then introduces very strange allegations which he has had to withdraw. Everybody saw his discomfort at making reference to those issues. But as we all observed, these issues around making allegations and running away from them are meant to cast aspersions and indirectly intimidate the court. Permit me to say, or to make reference to paragraph 8, where they say, for instance, that the petitioners have credible information that Honorable Justice Mrima is a close associate to the proposed Deputy President one Mr. Kindiki, and that the said judge failed, refused, or neglected to disclose that fact. Really, is that an issue that a party seeking the resolution of a matter that they brought under a certificate of urgency would want to raise to be a reason for a judge to disqualify himself? What is this association that we're talking about? What evidence have we tendered that there is anything that would be considered to be either untoward or that would make it inappropriate for the judge to sit in these proceedings? In fact, they go on to add, in a paragraph that they sought to, one of the paragraphs at paragraph 10, they say that this close association between Honorable Justice Mrima and the proposed nominee for the position of Deputy President of the Republic of Kenya might have caused this court to convene and sit on a Saturday with a view of assisting one party in these proceedings. Is that not outrageous, to say the least? We go on to say, at paragraph 11, that the petitioners are in possession of credible information that Mr. Justice Ogolla, who is the presiding judge in these proceedings, is conflicted as his spouse is a member of a Kenya Water Board, having been appointed by the President of the Republic of Kenya, who has in haste nominated Mr. Kindiki as his principal assistant. Allow me to pause on that allegation for one moment. What evidence do they present? Absolutely none. Today, let me take one step back. Yesterday, when the court was rising, we did put them on notice that we would seek to cross-examine the deponents of the affidavits that contained these very unfortunate averments. To try and cure that, they've then introduced a gazette notice. In that gazette notice, my lords and my lady, they then seek to say, gazette notices speak for themselves. The gazette notice says, that is gazette notice number 7515, in the exercise of powers conferred by those provisions of the law, I appoint Rose Ombaki and Florence Auma Oluoch to be members of the Kenya Water Towers Agency Board for a period of 3 years with effect from 9th of June 2023. The appointments via gazette notice number this and this are thereby revoked. That gazette notice is signed by the Cabinet Secretary for Environment, Climate Change and Forestry, Soipan Tuya. At what point, my lords and my lady, at what point does it become that it is His Excellency the President who appointed I want to use the words. His spouse is a member of the Kenya Water Towers Board, having been appointed by the President of the Republic of Kenya. When we come with such outright lies, what are we trying to do to the court, to the individual members of the court, to the parties before these proceedings? Is it a case of saying that we will get out of that court by all means necessary, including by peddling lies? My lords and my lady, these are the grounds upon which you're being asked to recuse yourselves. I've also seen there was, just give me 1 second, there was an equally strange averment about Lady Justice Freda Mugambi. Paragraph 16. Okay, let me just get that. Get to that. Get to that. Thank you. That Lady Justice Mugambi is conflicted as such as she could. Wait a minute. No, it's not this one. But there is an averment to the effect that Lady Justice Frida Mugambi was a student. 16. Okay. Yes. That Lady Justice Mugambi is conflicted as such she could recuse herself as she was Mr. Kithure Kindiki's LLM student at Moi University, a crucial issue that she refused and or failed to disclose to the parties at the inception of a trial. My lords and my lady, the qualifications of our judges are not secret because they're state officers. You only need to go to the website of the Judicial Service Commission and you find the truth. My lords and my lady, when we saw this very strange averment, we took the trouble to go to the website of the Judicial Service Commission and we established that Her Ladyship Justice Wilfrida Mugambi got her LLM from Birmingham University in the UK. How then do we want to bring these lies and feed them to the people of Kenya, feed them to the court, and expect that on account of such flimsy, concocted material, then the court should recuse itself? Again, is it a case of us saying, by all means necessary, we shall not appear before that court? My lords, my ladies, there are clear standards and thresholds that have been established both by the regulations governing the conduct of the court and even case law. That, my lords and my lady, first, you exercise your conscience as to what should make you recuse yourself. Number two, in the event that a party is raising a concern as to your recusal, then it must be a substantial issue. It must be a substantial question that has been brought before you. It cannot be that every frivolous allegation that is brought before the court should make the court down its tools. That, my lords and my lady, will amount or will create or facilitate an environment where forum shopping will be rife. We'll just need to mention anything, that I went to school with so-and-so, that I go to church with so-and-so, that I traveled with so-and-so, and that should be a reason for them to recuse themselves. That certainly cannot be the standard. My lords and my lady, I would refer you to one of the decisions in our bundle and list of authorities. That's UNAD, Ex parte CJL 1986, 60 AL JR 528, where the court had this to say, that although it is important that justice must be seen to be done, it is equally important that judicial officers discharge their duty and do not, by acceding too readily to suggestions and appearances of bias, encourage parties to believe that by seeking the disqualification of a judge, they will have their case tried by someone thought to be more likely to decide the case in their favor. My lords, my lady, the question that we'll be asking ourselves is, what is that fundamental question that has been presented? And why this is an important concern is because sometimes such frivolous grounds are raised purely to embarrass the court. On this occasion, I have absolutely no doubt in my mind that the net effect of what these allegations have done is an attempt at embarrassing the court. My lords and my lady, we urge that you resist that invite. You resist that temptation to ask the court to recuse itself on the basis of such flimsy, baseless allegations. Just to further speak to the fact that this is an attempt at embarrassing, if not intimidating, the court. Our friends for the applicant have also indicated that they have simultaneously sent or lodged a complaint with the Judicial Service Commission. Following from the submissions that I made reference to in the ruling about intimidating the court with the radical surgery, again going to the question of presenting this application for recusal after the one yesterday, and now going to lodge a complaint to the Judicial Service Commission, is that not an attempt at intimidating the court? My lords and my lady, I would not ask for an answer. That is an issue that anybody, any reasonable person out there would be able to make an indication or a determination about in their own space. My lords, my lady, is it also possible that this could be one of those issues that the applicants, or rather the respondents, have complained of as being a delaying tactic? Because we raised concerns yesterday. We are raising them again today. We have spent a whole afternoon arguing about issues that on the one hand had been completely determined by this court. The second part of those issues are issues that did not have any grounding, any material, or in support whatsoever. Are those not meant to delay these proceedings by any means necessary? Having taken cognizance of the fact that we came to you, both parties, under certificate of urgency, these matters must be treated with the urgency with which we came. And so we ask, my lords and my lady, that you dismiss that application with the contempt it deserves. May I now invite my learned friend, Mr. Nyamodi, to speak to a few of the remaining issues. My lord.
My lords, my lady, I wish to commence my submissions in opposition to the application for recusal before you this evening by tendering an unreserved apology on behalf of the members of the bar who have been urging and opposing the application before you today. Despite my relatively few years at the bar, I appreciate that prosecuting an application for recusal, and I have some experience in prosecuting applications for recusal, and it will become apparent in a moment, are not easy applications to prosecute. But the reason that I offer the unreserved apology is that it is my humble and respectful position that however difficult they are, there is no need for them to be prosecuted in as bad-natured a manner as these applications have been prosecuted before you. And for that, I am sorry. The only mistake that your lordships and my lady have made is to serve your nation as judges of the High Court and choose to sit in this matter. We have been told that there is no difference between this matter and any other matter, and I affirm that there is no difference. It is a matter just like any other matter. I wish to start by perhaps completing a submission that was made and not completed by my learned colleague, Mr. Gumbo, who submitted a few moments before. The issue of your recusal was not just an issue in the grounds, in the notice of motion that you determined yesterday, but it was contained in prayer 5 in that notice of motion. And I do not understand why the petitioners complain of bias or any improper treatment by this court. Because again, in my few years at the bar, in my relatively few years at the bar, seldom have I come across an application dated today, heard on the same day, and a substantive ruling running to in excess of 40 pages delivered the next day. So that issue has been dealt with conclusively by the court in yesterday's ruling. I wish to then focus on the authority that was cited in the dairy matter. And again, in my relatively few years at the bar, I have had the privilege of arguing several matters in the Supreme Court. Many of them are precedent setting. Dairy is one of them, and I did not know dairy would be one of them. But the ruling of the Supreme Court delivered in the dairy matter on the 11th of October this year has confounded me for a few reasons. I am still trying to understand what the meaning of that decision is. and I will share with your lordships some of my, some of the issues I have with that decision, and hopefully in your ruling you will help me understand them. The decision in Dari is not available as an authority for what the petitioners cite it to be. And one of the issues that confound me with that Dari decision, and if my lords, my lady, when you retire to consider your ruling in this matter, you take a moment and find the original script or the original version, not the one reported in KLR, but the one that is on the Supreme Court's website and was circulated to us on the 11th of this month, you will find that at the beginning of that ruling, Paul Nyamodi, yours truly, is referred to as senior counsel. Now, I cannot insist that I'm senior counsel because the Supreme Court referred to me as senior counsel in that ruling. That is the first issue that confounded me with that ruling. The second issue is that there was no application for the learned judges of the Supreme Court to recuse themselves. There being no application for the learned judges of the Supreme Court to recuse themselves, learned judges of the Supreme Court did not then have the benefit of argument from counsel for either of the parties as to whether or not they should recuse themselves or not. And if you look at that Dari decision, you will not find anywhere.
Perhaps you are disparaging the Supreme Court.
I am not. I am speaking about their decision. If you look at that decision, in the disposition at the end of that decision, the Supreme Court does not declare that it has recused itself. So if you were to extract the order, the issue of recusal would be absent. So in respect of that, I wish to submit that the issue of recusal in the Dari matter is then obiter. Having not been an issue before court, and having not been an issue that parties submitted to, it then cannot become an authority. It cannot then be cited as an authority for recusal. The second issue about the Dari decision, and the second reason why I say that Dari is distinguishable, is as follows. Unlike in this matter, where the issues, where the facts upon which the application for recusal are based have been judicially considered and a decision given, and that decision is contained between paragraph 74 and paragraph 96 in the decision you delivered in this matter yesterday. In Dari, the issues that the Supreme Court then suo moto relied on to recuse themselves had not received any judicial consideration. Yes, those facts went on to become a complaint before the Judicial Service Commission. In the same way, the facts that form the basis of your determination between paragraph 74 and 94 of your decision have gone on to the Judicial Service Commission as a complaint. But those facts now forming your decision, the proper thing to do is not to complain to the JSC, but to appeal. That is the proper thing to do. So to then file a complaint before the JSC and then reach for Dari out of context is wrong. And for those reasons, that Dari decision is distinguishable. And I urge you to distinguish it. The second decision that I wish to urge you to distinguish is the decision that was cited by my good and learned friend, Mr. Tom Masharia, the Navin Premji Kerry versus Virunga Limited decision. And the reason I want to urge you to distinguish that decision is as follows. A true reading of paragraph 5 and paragraph 6 of that decision show that the arbitration commenced on the 31st of March 2021. The traditional wedding which the judge then took offense to took place on the 18th of February 2022. So it is clear, and that is clear from a reasonable process of deduction, that the traditional wedding then took place during the currency of the arbitration. That is not the case here. The screen grab that has been produced of Mr. Justice Mrima and the Speaker of the Senate, if we are to believe that it is true, is dated the 9th of October 2021, more than 3 years ago. So this decision is distinguishable on the facts. Judges do not live in glorious isolation. Your appointment as a judge does not mean that you cannot invite your friends to a wedding. On the 9th of October 2021, Mr. Justice Murima did not know that he would have to go through the torment of sitting on this bench. In respect of the Manchester Outfitters decision, I also submit that that decision is distinguishable for the following reason. Mr. Justice Laka had been an advocate for one of the parties. Again, in an advocate-client relationship, the client pays the advocate fees. And that relationship is not at play here. And for those reasons, I urge you to distinguish that decision. My Lord, there are two pieces or two annexures that we wish to make a specific submission on. And that annexure is the screen grab from Amason Kingi's account and the prophecy by learned senior counsel Ahmed Nasir as to what would take or what is going to happen in this matter. My Lord, those are electronic evidence. And those are electronic evidence I submit within the meaning of Section 106B of the Evidence Act. In the absence of a certificate required by Section 106B of the Evidence Act, that evidence is not admissible. My Lords, it has been submitted by those who have submitted before me in opposition of the application that the petitioners are guilty of forum shopping. I wish to persuade you whilst on my feet this evening that this application is a further attempt at forum shopping. My Lords, my Lady, you will not, because you are seized with petition number 522 of 2024, that on the eve of the impeachment hearing, the petitioners insisted at an hour not too different from this that you hear their application for conservatory orders. The application was heard, and you, with exceptional dispatch, delivered the ruling the next morning at 8:30 in the morning. My Lords, my Ladies, after the ruling, the learned counsel who are in court for the petitioners engaged you in a lengthy submission, which appears to be their stock in trade, on a request for leave to amend that petition. And the requirement or the request that they wanted, or the reason why they wanted leave, was they envisaged that perhaps after the impeachment proceedings in the Senate, there may have been need to have recourse to court and seek certain orders. But what did the petitioner do? The petitioner, and we are told that he was unwell, as he was unwell, issued instructions for this petition to be filed, for petition 565 to be filed, and conveniently this petition did not come to this bench. This petition went before another court, and surprise, 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 before that court they got their orders. And it is those orders that they seek to defend here today. A request that they seek to defend here today. A request for you to recuse yourself is in furtherance of their attempt to forum shop. And my Lords, my Ladies, as I take my seat, I urge you to bear in mind the finding that you have already made about these petitioners. Paragraph 98 of your decision and paragraph 99 of your decision rendered this morning, or rendered yesterday, which with your permission, I ask to read. Counsel also insinuated that this bench is part of a conspiracy to violate the petitioner's rights to a fair hearing under Article 50 of the Constitution. These submissions are without foundation and wholly without merit. The court has not issued any rulings or directions that would suggest such an intent. It is apparent that this argument was made for the gallery, and we find it unnecessary to address it further. This is in furtherance of that disposition of the petitioners. This is a serious matter. As has been submitted by my learned colleagues, you have a duty to sit, and we urge you to sit and dispense justice in this matter. I'm most obliged.
My lady and my lords, hot on the heels of submissions by Mr. Manyamodi, now senior counsel, I wish to state as follows. My lady and my lords, the serpentine and sinuous submissions by Ndegwa and by my learned friend, senior counsel John Aminwa, just in case he says I was breastfeeding, must be faulted for two reasons, my lord. My lord, one, Mr. Aminwa refers to the Richard Nixon impeachment as the first impeachment, when it is clear, my lord, that in the US, the first impeachment was that of President Andrew Johnson in 1868, coming after he dismissed a war general, Mr. Stanton. The Richard Nixon impeachment was the second impeachment coming in 1974, because you said that was the first impeachment, and Nixon resigned. It's just important for context, my lord. Yes, my lord, it's just important for context that in the second impeachment of Richard Nixon, he resigned on the 8th of August, 1974, and thereafter, the next president, Ford, took over for the next 3 years. I think it is instructing, my lord, to refer to this impeachment because of the case of...
Nixon was never impeached.
He resigned. I've said he resigned. After the Watergate scandal, the impeachment commenced and he resigned. And that is what gentlemen do when an impeachment is imminent. My lord, I want to connect this to my submissions that we shall be relying on the political question doctrine and the finality of impeachments by Senate in a comparative context. My lord, let me submit that in Gladys Beausoleil versus JSC, this court set out a threshold for recusal. And the threshold is, my lords, that a recusal application must be made in good faith. And if the court listens to the histrionics from the petitioners, the courts will note that the application is not made in good faith. It is tied to an intention to extend ex parte orders that advantage the petitioners. The petitioners are intent, my lords and my lady, on scuttling the bench and scaring them away from sitting so that they can have open-ended and irregular orders issued in Kerugoya by Justice Richard Longo. Then they went to the second act of actually filing a complaint with the Judicial Service Commission submitted to Isaac Wamasa and duly acknowledged, so that this court can be scared away and run away. My lord, then the scheme was not complete. My lord, Judge Ibrahim, at page 31 of the Gladys Beausoleil decision, stated, my lord, that the threshold for impeachments cannot, for recusal cannot be so low, and every allegation made of any form of bias must be proved through credible evidence. My lord, I dive straight to section 11 of the Oaths and Statutory Declarations Act. the petitioner's affidavit. The petitioner made a false affidavit through a deponent who swore to factual issues that the petitioner then attempted to withdraw in court. My Lord, that not only invites a criminal sanction under Section 11, but what is more important, my Lord, is that false affidavits are no affidavits and must be struck off. Because the penultimate paragraph in an affidavit, my Lord, swears to the truthfulness of the whole document. Where therefore, my lords, any part of that document is false, the affidavit must be struck off. My Lord, we further submit that to both applications, my Lord, that are before you, parties having been unable to meet a threshold that would warrant the disqualification of all the judges sitting in this bench, that the applications must fail. I have no doubt, my lords, that we have cited relevant authority. We have cited the authority in Jackson, Molalu, and others, a Court of Appeal decision on the threshold that learned friend Senior Counsel Hamina wants to lower. He invites the court that at every mention of the possibility of bias, that the court downs its rules. My Lord, if that were the case, no judicial proceeding would be conducted in this country. And learned friend, Senior Counsel Professor Gideon, I told you of the number of students that he has taught. I think I've taught more young counsel in this room. And it would be impossible, my Lord, if association by way of sharing a classroom or teaching were a threshold or a test for bias, that judges would recuse themselves, my Lord. No judge, my Lord, would sit on any bench to hear any case, because we are all extracted from the same academic background and a daily trend. Unless my Lion friends are saying that. Yes, my Lord, in response to the suggestion that the Honorable Justice Mrima attended a wedding of the Speaker of the Senate, my Lord, the Speaker attended the wedding of the Honorable Justice. My Lord, the Honorable Justice Kingi, Amason Kingi, is a peripheral party in the proceedings. Indeed, if you look at the proceedings, my Lord, what we have in the proceedings is not Amason Kingi as a party in his name. It is the office of the Speaker as a corporate office who is a defendant or a respondent in these matters. But number two, my lords, the Honorable Speaker Kingi merely presided over the proceedings in Senate and was not a voting member in the sitting of Senate that led to the impeachment of the former Deputy President. My Lord, the Honorable Kingi has not taken part in the appointment of this bench in any form. My Lord, clearly, the petitioners are clutching on straws, and every attempt at ensuring that this court does not proceed seems to be falling by the wayside. I urge the court and I invite the court to consider this application for recusal as another attempt to frustrate the processes of this court and to ensure, my Lord, that this bench does not proceed to dispense justice that ought to be dispensed expeditiously in line with the Constitution. I pray, my Lord. My Lord, on the appointments of judges, my Lord, clearly, if peradventure the argument on conflict extended to who appoints, my lord. The president appoints all judges, and is a party. I think they should have added that ground, perhaps, because the president appoints all judges. But that cannot be a cause for a party seeking a recusal, my lord, because the president, in performing a constitutional mandate, just like, my lord, the CS Environment Soipantria exercised her statutory mandate in appointing Florence as a board member, my lord, cannot be a cause or a basis for seeking or asking for conflict. My lord, soon parties will then apply for recusal on the basis, my lord, that two judges or a litigant and a judge belong to the same community. Thank you, my lord.
Sorry, none of them is quite near me, so I think I will. Thank you. Thank you very much. Just a brief rejoinder to the application, and especially in view of what has actually been disclosed after the arguments. And my lady and my lords, I would be urging you kindly to actually go through these voluminous decisions we have given to you, because part of what some parties are submitting and saying it falls on all fours in relation to the matter before you is nothing far from the truth. And the example that has been cited is that of Erai and Virunga Limited, where it has actually been shown that that authority cited does not in any way relate to what is before you in terms of facts and the applicable law. It has been clearly demonstrated that here disclosure was necessary because...
Just a minute. We wish to adjourn for 10 minutes. You can take health break for 10 minutes.